Welcome to our YouTube channel, which is created by Advocate Madhuri Lawan and Advocate Mahesh Devlekar, which is supported by Mr. Vishwajit Lal, Mr. Rajesh Pawar sir, Mr. Sandeep sir, and Senior Advocate Mr. Dhananjay Deshmukh. We have started the Indian Contract Act 1872, Part First. Definition of contract. Some important part. Definition of contract. Salmon said it is an agreement creating and defining obligation between the parties. Pollux defines contract as every agreement and enforceable at law is contract. We are seeing the important parts, definition and concept. Section 2H, Section 2 bracket by the H of Indian Contract Act 1872 defines the term contract as an agreement enforceable law. An agreement is a promise, is an accepted proposal. Question. Rescission of the contract means answer is D. Cancellation of contract. Explanation. Section 19 Indian Contract Act deals with the effect of law in consent caused by coercion, misrepresentation and fraud, and Section 19A when the consent obtained by undue influence, a contract induced by coercion, undue influence, fraud or misrepresentation is voidable at option of the party whose consent was so caused, that is a right of rescission of contract. Question. In case of joint promise, generally the performers must buy. Answer is D. All of the above. म्हणजे A, B, C बरोबर. Some of them to perform, any one of them to perform, all the joints promiser to perform. Question. Contract without consideration made in writing and registered and made on account of natural love and affection. Answer is A. Valid. Bracket मध्ये explanation. The validity of a contract is essential that the consideration and object should be lawful. If object is not lawful, the contract is void. The object and consideration may in some cases be the same thing but may also differ. Question. A guarantee can be oral or in writing. Explanation. Section 129 of Indian Contract Act. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. And question. An agreement by way of wager under Section 30 is answer is C. Void. Explanation. An agreement by way of wager is void Section 30, but it is not immoral. The word wager means a bet. In wagering agreement, two parties have opposite views regarding an uncertain event, and they stipulate that upon the determination of the event in a certain way, the parties shall win or lose from each other a certain sum of money, and the parties have no other interest in the event except winning or losing a bet. Question. In case the promise prescribes the manner and time performers, answer is C. The performers must be in the manner and the time of prescribed. Explanation. Obligation of parties to contracts. Section 37. The parties to a contract must either perform or afford to perform their respective promises unless such performance is dispensed with or excused under the provision of this Act or of any other law. Under Section 2B, if the person to whom the proposal is made signifies his assent, the proposal is said to have been, answer is D, accepted. Question. A proposal stands revoked. Answer is D, all the above. A proposal stands revoked by death or insanity of proposer to the knowledge of the acceptor. by communication or notice of revocation by the possessor, by failure of acceptor to fulfill a condition precedent. Section 3 to 8 lay down the certain rules relating to communication and revocation of proposal and acceptance. 1. Communication, acceptance and revocation of proposal bracket means section 3. 2. Communication of proposal and acceptance. 3. Communication of proposal when complete section 4. 4. Communication of proposal when complete. 5. Communication of revocation when complete. 6. When proposal may be revoked, section 5. When acceptance is revoked. Section 74 applies. Question. Section 74 applies. Here answer is in both A and B. Means section 74 applies where the actual damage or loss has been proved to be caused by breach, where the actual damage or loss has not been proved to be caused by breach. Section 74 of the Indian Contract Act. Explanation. Section 74 of the Indian Contract Act lays down a slightly different rule compensation for breach of contract where penalty stipulated for when contract has been broken if the sum is named in the contract as the amount to be paid in cases of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled whether or not actual damage or loss is proved to have been caused thereby to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named or, as the case may be, the penalty stipulated for. Case law Mahabir Prasad vs. Durga Datta, AIR 1961 SC 990. A question. A contract not specifying the place of performance. Answer is C. The promisor has to apply to the promise for appointment of a place of performance and performance the promise at that place. Question. An agreement enforceable by law is a contract. Question. If founder makes a default in payment of debit at the stipulated time, answer is D. Answer is D. The pawnee has the right to sell the goods pleased after receiving reasonable notice of sale to the pawnee. Explanation. The bailment of goods as security for payment of a debt or performance of a promise is called pledge. The bailer in this case called the pawnee and the bailee is called pawnee. Question. When at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promised to do or to abstain from doing something, such act or absenteeism or promise under section 2D is called consideration for the promise. A contract of indemnity as a contract by which one party promises to save one party promises to save the other party from the loss caused him by the conduct of the promiser himself or of any other person has been defined under section 124. Important points for JMFC Pre-India Contract Act. Contract is an agreement enforceable by law. Rights and duties created by the agreement are enforceable by law. The object of the agreement must be lawful. Voidable contract enforceable by law at the option of one or more parties to the contract, but not at the option of the other or others. Question. In case of breach of contract, compensation can be claimed under section 73. Answer is B. For the proximate and natural consequence of breach. Next question. Every promise and every set of promises forming the consideration for each other is an agreement. Question. Principal is a answer is C. Person for whom the act is done or who is so represented in dealing with third person. Important points. इंडियन कॉन्ट्रॅक्ट ऍक्ट मधील काही इम्पॉर्टंट पॉइंट्स आहेत. हे इम्पॉर्टंट पॉइंट तुम्ही ऐकल्यानंतर तुम्हाला MCQ सोडवणं सोपं जाईल. पॉइंट बघू आपण. मेजर पर्सन इज कम्पेटेंट टू कॉन्ट्रॅक्ट. Agreement with minor is void ab initio. Agreement with the minor is void ab initio was decided in Moore v. versus Dharmadas Ghosh. ही केस महत्वाची आहे. मोर v. versus Dharmadas Ghosh. Next point. Void agreement means agreement not enforceable by law. When the proposal is accepted, it becomes promise. The person who makes a proposal is called a promiser or offerer. Goods in a showroom which has a label showing price is an invitation of offer. The communication of proposal is complete when it comes to the knowledge of the person to whom it is made. Agreement which is enforceable by law is made with pre-consent, having lawful object and lawful consideration between the parties competent to contract. Future consideration is called executory consideration. Agreement is restraint of marriage is void. Question. Revocation of offer by letter or telegram can be complete when it is discharged. Question. Which one of the following does not amount to fraud? A. Representation made without knowing it to be false, honestly believing it is to be true. In estimating the damage, the means available with the party claiming damage to minimize the damage shall be considered. Under section 74, the court cannot award damages more than the amount stated in the contract. An agreement enforceable by law at the option of one party, not the other party, under section 2R is for avoidable conflict. A contingent contract based on the specified uncertainty becomes void if the happening of that event becomes agreement of which is not certain, capable of being made certain under section 29 is void. Important points. When consent is obtained by fraud and the contract becomes voidable. When consent is obtained by undue influence or coercion, the contract becomes voidable. Agreement in restraint of trade is void. Proposal is said to be until it is accepted, rejected, or revocable. An acceptance communicated by words of mouth, spoken or written is called express acceptance. An agreement to remain unmarried is void. In contract, consensus ad idem means meeting of minds upon the same thing in the same sense. Contract made out of love and affection is a valid contract, where under a contract if the consideration paid is inadequate, then the contract is enforceable at law. Inadequate consideration helps in determining free consent. A contingent contract on the happening of an uncertain future event can be enforced on the happening of the event. A contingent contract becomes void when the event becomes impossible. Claim for necessaries of life supplied to a lunatic under Section 68. Answer is B. Can be enforced against the lunatic or estate. Property or estate. Question. Agent is a answer B. Person employed to do any act for another or to represent another in dealing with third person. Communication of acceptance is complete as against the acceptor. Answer when it comes to the knowledge of the proposal. Under Section 74 of the Code cannot award damages more than the amount stated in the contract. Who can appoint an agent? Answer B. A measure of sound mind. Question. Under the contract of guarantee, the liability of surety. Answer is D. Both B and C. But under the contract of guarantee, the liability of the surety cannot be limited and has no extent to the whole of the amount due from the principal, can be extended to penalties also. For the act of supervision lawfully appointed, the supervision is responsible to the principal directly. Proposal as defined under Section 2A is a willingness to do or abstain from doing an act, obtain from doing an act, in order to obtain from doing an act, in order to obtain the asset of the thereto. Thank you for watching this contract act MCQ part 1. मी तुम्हाला विनंती करतो की जे ॲडव्होकेट माधुरी लावण आणि ॲडव्होकेट महेश सर यांनी एक्सप्लेनेशन दिलेलं आहे, कारण का त्या एक्सप्लेनेशनवर MCQ मध्ये काय आहे, म्हणजे कशामुळे तिथं उत्तर आलेलं आहे ते तुम्हाला समजू शकेल. ते तुम्ही शांतपणे ऐकून घ्यावे आणि समजून घ्यावे ही माझी नम्र विनंती. तुम्ही सर्व विद्यार्थ्यांचा विचार करता तर आम्हाला जो मेल आला त्यामध्ये विनंती करण्यात आली की सर तुम्ही एक्सप्लेनेशन पण त्यामध्ये द्या, म्हणून एक्सप्लेनेशनचा पार्ट ऍड केलेला आहे. I am thankful for the watching this YouTube channel and keep watching, and also I requested you to keep ready for examination and study hard, listen a lot, read a lot and listen a lot. Thank you for watching our YouTube channel.